Appeals of Tennessee is now in session.
Good afternoon. Before we start, the council, we appreciate you all participating in this process for arguments by Zoom. We hope to be back in the courtroom sooner rather than later now. We're at least approaching that time. If we should have any technology related problems, we'll just all take a deep breath and pause while Mr. Hibner and the AOC folks work it out for us, and then we'll take back up. Sherman, call the case, please.
Yes, Your Honor, this is a consolidation of 5 cases, which I'll refer to for purposes of this argument as Alisa Bibbs et al. Versus Durham School Services LP et al.
That'll be fine. We'll hear from the appellant.
Your Honor, this is Mike Campbell in Chattanooga, Campbell and Campbell. We are local counsel for Durham in this area, and I and Lauren Turner have been representing Durham, and I'm introducing to you this morning or this afternoon Melissa Murphy-Petros, member in good standing of the bar in Illinois, also licensed in New York and in a number of federal courts, and she will present the argument for Durham and National Express.
That'll be fine. Glad to have you here, counsel. Mr. Hibner, won't you start it back at 15 minutes again? Thank you. We'll hear from you.
Thank you, Your Honors. Good afternoon, and may it please the court. Melissa Murphy-Petros of the Illinois Bar on behalf of the defendants, appellants, Durham School Services and National Express. And as we did in our briefs, I will refer to the defendants collectively today as Durham. I will start with the issue of whether plaintiff Brenda Cothran has sufficiently alleged a claim for negligent infliction of emotional distress, and then from there move to the issues which this court certified with respect to all of the plaintiff's claims for intentional infliction of emotional distress based upon recklessness. First, Ms. Cothran has not sufficiently alleged a prima facie claim for negligent infliction of emotional distress. One of the required elements of this claim, as set out by the Supreme Court in Eskin, is the existence of a close and intimate personal relationship between the plaintiff and the third-party victim, here are the children on the bus. Ms. Cothran's claim fails because she does not allege facts which describe a close and intimate personal relationship between herself and the children on the bus. She alleges in her operative amended complaint that she was the school principal, that she encountered the children at school during the day, that she spent long days at school with children, and that she knew the children of Woodmore Elementary and their parents. And from these allegations of fact, she concludes that she had a close, intimate, and personal relationship with the students, and that she was in fact in loco parentis with them. Ms. Cothran's allegations, describe her role as a school principal, but they do not allege any facts supporting her conclusions of the required close, intimate, and personal relationship. And this is so for 2 reasons. First, in the operative complaint, Ms. Cothran refers to her relationship with the children on the bus as a collective group. And there has been no case that we've identified in Tennessee or in fact anywhere else which allows recovery for a non-bystander negligent infliction of emotional distress claim based on a purported relationship between the emotional distress plaintiff and a large collective nondescript group of individuals. And in fact, such recovery would be counter really to the purpose of this claim, which is predicated upon the specific relationship between the plaintiff and the injured third party. Second, there are no facts pled in Ms. Cothran's operative complaint which satisfy Eskin's criteria for a close and intimate personal relationship. Now, in Eskin, the Supreme Court did say that such a relationship is not necessarily limited to those formed by blood or marriage, but it must be a familial type relationship. And Eskin specifically lists several examples: parents and children, spouses, siblings, immediate family members, engaged parties, step parents and stepchildren, and in fact uses words repeatedly such as near and dear ones and loved ones. And all of these references strongly suggest that the Supreme Court in Eskin intended the permissible realm of non-bystander plaintiffs for this claim to remain limited to those who have intimate emotional bonds with the injured party and not broader than that. Here again, there are no facts alleged in the operative complaint which even remotely describe a close and intimate personal familial type relationship between Ms. Cothran and the children on the bus. She does allege that she performed her duties as the school principal with respect to all students at the school. In fact, she does not allege that she performed her duties only with respect to the children on the bus, but fulfilling those duties simply does not satisfy the requirement that she plead facts describing a specific relationship between herself and each of the specific children on the bus. Finally, before I conclude on this, one final point bears emphasis. She is a non-bystander. She did not witness the accident. And I think it's very safe to say that if her relationship allegations survive a Rule 12 motion and get a case into discovery and potential trial with the exposure and expense that entails, then really virtually any negligent infliction of emotional distress claim brought by a non-bystander in any context would survive a Rule 12 motion. And that is counter to the Supreme Court's admonition in Eskin that the court determine at the earliest possible stage which plaintiff should be pursued or allowed to pursue a negligent infliction claim going forward and which should not. Second, all 5 plaintiffs have failed to allege conduct which is so outrageous that it's not tolerated by civilized society for purposes of their claims for intentional infliction of emotional distress based upon recklessness. Here, the conduct which plaintiffs allege to be so outrageous is Walker's conduct at the time of the accident, for which Durham is vicariously liable pursuant to respondeat superior, and Durham's hiring, training, retention, and supervision of Walker. The Supreme Court in Bain instructs us to look to the restatement of torts to determine what conduct is so outrageous for purposes of this particular claim. And that conduct is conduct which is extreme and outrageous. And the Supreme Court in Doe stated specifically that this is a very high hurdle for a plaintiff to overcome. It's an exacting standard. The character of the conduct must be outrageous, and the conduct must be sufficiently unusual to be extreme. And it has to be both. The two go together and are not to be separated. Here, the alleged conduct of Walker and Durham does not meet this criteria for purposes of the intentional infliction of emotional distress claim. With respect to Walker, the conduct alleged is that he is a poor driver. And allegations of poor driving, we all know, come up in all kinds of cases. There's
all right.
Yeah, I'm sorry. Go ahead.
Who wants to go? Ms. Murphy-Petros, it goes a little bit beyond just he's a poor driver. The allegation is that this man, I believe in the course of the 4 months that he worked there, there were notifications of him speeding over 1,000 times. But even more concerning, I guess, is the allegation that he intentionally took actions to try and injure these children, including the few days before this accident occurred. I think the allegation is there's videotape of him swerving, trying to get the kids on the bus to hit themselves with the seats. That can you not agree with me, is beyond just poor driving. That's pretty close to outrageous, if not there.
Well, I think that those allegations, I mean, yes, the allegations are significant, and they certainly describe, recklessness. But the restatement tells us, and Bain emphasized, that, even allegations of criminal conduct are not necessarily going to be considered extreme and outrageous for purposes of an intentional infliction of emotional distress tort. Again, I think when we look at Walker's conduct and then combine that with the allegations against Durham, that Durham is vicariously liable for Walker that Durham was negligent and reckless in its hiring and training, et cetera, of Walker. These really are the types of claims that we see in literally every transportation accident. It's almost, it doesn't really matter. It could be a bus, a plane. Every time you see a transportation accident, you're going to have these types of allegations.
You'll have these types of claims, but I don't know that you're going to have these specific facts.
I think the facts that have been alleged in the complaints go to, the recklessness component and even perhaps the outrageousness component, but it still needs to be so unusual that it really is, beyond the pale. And when you look at the cases where that has been found, the Lorsey case comes to mind, the mail carrier who witnessed a shooting. When we look at these transportation cases, this is just not the kind of conduct which is so unusual to be extreme for purposes of an intentional infliction of emotional distress claim based upon recklessness. And again, for purposes of plaintiffs who, did not witness the accident as it occurred, and who, as I'll discuss next, do not have the requisite close relationship with the injured parties. And before I move on, did you have a question, Judge Sweeney?
Judge Davis asked it.
Okay, thank you.
Thank you.
No problem. So I will now turn to the third issue, which is that the plaintiffs have not sufficiently alleged that they are persons who fall within the reasonably foreseeable scope of Durham's alleged conduct here. Plaintiffs' allegations of reasonable foreseeability are that Durham, knew or should have known that if there was a school bus accident, school teachers and staff could be upset by that. But if plaintiffs, again, are correct on this, then really every transportation accident will give rise to this claim. We can't just look to this particular, we have to look at the accident with a focus and not broadly. And, common sense tells us really that any accident anywhere will cause emotional upset to somebody somewhere. We need to look at this specific plaintiff and these specific injured third parties. It's really more of an after the fact analysis as opposed to looking to a future hypothetical, which is what plaintiffs have alleged. We submit that the appropriate analysis to be undertaken in assessing reasonable foreseeability here is to look at the factors set out in Ramsey and Eskin with respect to foreseeability in the context of negligent infliction of emotional distress claims. The plaintiff's physical location at the time of the accident and awareness of the accident, the degree of injury to the third party victim, and then of course the relationship between the specific plaintiff and the third party victim. And looking at those factors here, plaintiffs, again, have not sufficiently alleged facts which go to these elements. All of these plaintiffs are non-bystanders. They did not see the accident as it occurred. They do not have, they have not alleged facts describing a close relationship with the children on the bus. I discussed Mrs. Cothran, so I won't repeat my discussion there. But with respect to the other four plaintiffs, they all allege facts describing their roles as educators in the school and what they did for the children of Woodmore Elementary. And they are certainly have described that they are very dedicated educators, but they have not, they have not alleged facts describing their individual relationships with the individual children who are on the bus. Again, they describe, they conclude that there's a relationship with this group of victims, but without the specific facts alleged, which certainly, if those facts are true, if they had these types of very close family relationships with each of the children on the bus, they would be able to allege that. They haven't done that. And those are the facts which are necessary to sustain this claim, at least for purposes of surviving a Rule 12 motion. If there are no further questions, I will hold my time for rebuttal.
Thank you. You do have your time for rebuttal. We'll hear from the appellees.
Judge Swinney, Judge Frierson, Judge Davis, Art Grisham from Chattanooga. I represent the Ms. Cothran, who is the principal of the school where these children attended daily. We've alleged a close personal relationship. We've alleged in loco parentis. I read the Eskin versus Barty case quite differently from Ms. Murphy-Petros in that I believe in that case, the court actually said that the burden is on the plaintiff to prove the existence of the close and intimate personal relationship, and the defendant may contest the existence of the relationship. I think that's a matter of proof. We have alleged enough to proceed to trial. I believe that the Eskin versus Barty case is the last case in a series of cases that really began in 1996, I'm sorry, long after I had graduated from law school in 1972, at which time you could only recover if you were a close personal, in a close personal relationship and in the zone of danger. And we're far, far away from that now. In fact, the Eskin versus Barty case, as I read that case, says that there are 4 factors that the court is to continue to look at, and it recognized that there were a growing number of cases all over the country that were recognizing the right to recover for these negligently inflicted emotional distress type cases, and that the courts had to consider the physical location of the accident and where the plaintiff whether or not the person was aware of the event, the seriousness, apparent seriousness of the injuries, and the closeness of the relationship. And with respect to the proximity, that's the case that recognized that as long as the person didn't have to actually see the accident, but if they arrived upon the scene within a sufficient period of time, short period of time, and the scene was still unchanged, that was enough to satisfy the proximity requirement. I think we've alleged.
Mr. Grisham, I'm sorry to interrupt you, but does it matter in this case that your particular client, and really all of them, but yours is the one who went to the scene, that they voluntarily went to the scene of an accident or to the hospital, knowing kind of what they were going to get when they got there? Maybe not the extent of it, but certainly knowledge of a terrible accident with injured and potentially children who had perished.
Well, I do think that is significant, because Ms. Cothran, the other people that Mr. Burke represents, all dealt with these people in a very close relationship all day long. Mr. Burke's has produced evidence. His clients were bringing food for these children, bringing clothes for these children. They were that intimately involved. This is an economically depressed area that a lot of single moms and a lot of latchkey kind of kids. So there was an extremely close relationship between the administrators, the teachers, the principal of this school with these children.
But what I'm saying is this is different from a situation where someone happens upon a scene or is not prepared, I guess, for what they're going to see. But in some sense, these folks were, to the extent that they knew what had happened. So
I think they knew what had happened in general, that there had been an accident involving the kids. And then when they go to the scene of the accident, like my client did, and see injured, maimed, dead children lying on the scene, children pinned in and under the school bus, Mr. Burke's clients go to the hospital and are there when the children die from their injuries. It's not akin to a situation where somebody voluntarily exposes themselves. These people felt an obligation to care for these children from the time they got at school until they got home after school. And I think it was an ongoing obligation. Thank you, Judge Davis. Thank you, gentlemen.
Thank you, counsel.
May it please the court, I'm Ronnie Burke from the Chattanooga Bar. And I think to put this in perspective, we need to look at a case I didn't cite in my brief, which is Leach v. Taylor, 124 Southwest 3rd, 87. And there's three principles that come out of that case.
Counsel, I'm sorry, you said it wasn't cited in your brief.
No, Your Honor.
If you would, then just send a letter to the clerk, copying it to opposing counsel, and just give us, say this case was referenced in the argument, just give us the name of the case and the site, but no argument about it. Just the,
Thank you, Your Honor.
thank you.
It had three factors. This case involves a motion to dismiss. It's not a summary judgment. It's not a case that has been tried before the courts. And the Leach case says, number one, courts should liberally construe the complaint in favor of the plaintiff when considering a motion to dismiss for failure to state a claim. Secondly, courts should grant a motion to dismiss only when it appears that the plaintiff can prove no set of facts in support of the claim that would entitle the plaintiff to relief. And thirdly, it said that the courts are required to construe the complaint liberally in the plaintiff's favor and take the allegations of the complaint as true. This case, as has been mentioned, involved a school bus, no other vehicle involved, running off the road, was not on its route at the time, was speeding at the time, and the driver was using his cell phone, all of which the defendants knew prior to that day that the driver was doing. Ms. Murphy-Petros says this is like any other case. I've been practicing over 50 years and I've never had one this bad. Let me talk about a few things that are facts pled in the complaint. The defendants hired a 24-year-old male who had never driven a truck, never driven a bus, and allegedly trained him. The court found some facts, such as that there were over 1,000 notifications of him speeding. And this, he worked for about 6 weeks in the spring, but then worked 3 months in the fall. These speeding notifications only occurred when he was going more than 5 miles an hour over the speed limit. The notification showed he was going between 5 miles an hour and 25 miles an hour over the speed limit at least 1,000 times. The defendants had prior knowledge that the defendant driver intentionally swerved the school bus in an effort to intentionally try and injure the children, and the defendants even had a video of it. And they did nothing, knowing he intentionally tried to do this. The court also found that he should have been fired previously for violation of policy considerations, including their tardiness policy. The court found that he missed 5 out of 5 mandatory safety meetings. If you miss 5 out of 5 mandatory safety meetings, what does mandatory mean? The court found that the defendant had knowledge that the defendant driver Walker used his cell phone while he was driving the bus. And that was one of the factors that caused this crash. Even though that was supposed to be a zero tolerance policy, they did nothing. He had in the fall, in that 3-month period, 2 accidents, prior accidents that were his fault, and they did nothing about it. The court then looked at all of the requirements found in Doe versus Roman Catholic Diocese case and found that the plaintiffs fit all of those factors.
Mr. Burke, let me ask you about that. There's not really much analysis in the trial court's order about what I think is probably the seminal issue for us, and that is whether in Tennessee we are expanding the tort of negligent infliction of emotional distress or intentional infliction of emotional distress in the way that this case would do, meaning to this class of persons, not a family member, not someone who is a pseudo family member, even though I know you argue that they are in loco parentis, but we're talking about people who work at the school system with children. And you'll acknowledge that that's a pretty significant expansion of the class of persons to whom this tort would apply if we agree with what Judge Bennett did.
Well, I was always taught that it was not very smart to disagree with the judge, but respectfully, I would disagree with that. I'd like to just briefly touch on the prior law under negligent infliction claims. One, the Camper Court said that the purpose of tort law is to compensate those who have sustained emotional injuries as a result of the negligence of others, while balancing the need to winnow out frivolous claims. And that's kind of a theory through a lot of these cases. The court adopted a general negligence test and said that the case should be analyzed no differently from other negligence cases. And just quoting from the law, they said that negligent infliction of emotional distress cases should be analyzed no differently than any other negligence case, that the proper application of the familiar elements of negligence is the preferable way in which to sort out the genuine from the false and the serious from the trivial. The law kept evolving, and the Ramsey case eliminated the requirement of a family relationship and said you only need a close relationship. And I think we have certainly alleged more than enough in that area.
Well, let me ask you, I want to follow up on that. I mean, there were 3 issues certified. This is a Rule 10, and we're limited to what we certified the issues to be. And the second one there is whether the plaintiff's complaint survives a motion to dismiss by sufficiently alleging that plaintiff is a person who falls within the reasonably foreseeable scope of the particular substantial and justifiable risk consciously disregarded. You know, why, and I understand, but why are these plaintiffs, why do they fall within the reasonably foreseeable scope?
Well, first of all, I don't think under the Doe versus Roman Catholic Diocese case, it has to be within the reasonably foreseeable scope. As a matter of fact, that case specifically rejected. I know the appellant continually talks about restatement section 46. The Doe case specifically rejected that and said that in a reckless case, as opposed to an intentional infliction case or a negligent infliction case, that in a reckless infliction case, you don't know who it's going to be directed at because you're being reckless. And you don't need a directed type plaintiff or a specific plaintiff that could be pre-identified. The Doe case, additionally, and this is a distinction between reckless infliction and negligent infliction, is that the court system is there to winnow out the frivolous cases. The court should act as a gatekeeper, and Judge Bennett followed the law. I don't think this court needs to make any new law. I think we completely fall within the prior law. As a matter of fact, I believe and still believe that my case could have even or should have survived under negligent infliction because of the prior law that was passed in that area. The Lorsey case said even if there's no close relationship, it's enough if the plaintiff observed the death or injury or was in close proximity. We have alleged that all of my plaintiffs saw the kids in the hospital hooked up to tubes.
I'm sorry, let me go back. I mean, we understand the facts. I'm trying to understand, are you saying that it's no longer It's not required that the plaintiff be someone, not necessarily by name, but by class at least, someone who can be identified as to have been reasonably foreseeable that they might have suffered this as a result of the reckless infliction of emotional distress.
If it's a negligent infliction case, I think there are some requirements. I felt that my clients fell into that. The judge found that they didn't because they didn't visit the scene. But in the reckless infliction of emotional distress claims, there's only 3 requirements under the Doe case. One is conduct should be reckless. I think we've alleged more than enough of that. 2, that the conduct should be outrageous. I think that certainly when you know a driver is intentionally trying to injure kids, is continually speeding, and all the other things that we've alleged, I think certainly that is outrageous, and that it causes serious mental injury. We have alleged all these things in our complaint, and under the Leach case that I mentioned, the court should assume that all of the facts that we have alleged are true.
Well, again, I understand that, but are you saying that, I mean, what's the limit? Is there a limit as to who would fall for, as to who would be allowed to bring this suit for reckless infliction of emotional distress? Would it apply to neighbors of the children, for example?
Well, I think you have to show a close tie. And we
So
have alleged,
close neighbors would too.
well, just being a neighbor, I don't think would be enough.
Well, I said a close neighbor. Their children play together. I mean, is there any real limit? I mean,
There may be a limit in the negligent infliction world.
I understand, but I'm asking about on the reckless now.
On the reckless, no, Your Honor, as a matter of fact, the Doe case said that it need not be directed towards any specific person, and you don't have to occur in the plaintiff's presence. The Harris v. Horton case affirmed those 3 elements. The Rogers versus Louisville Land case said if it's reckless, you're liable even if you don't intend to cause emotional distress. And the Akers versus Prime Succession case said the same thing. I would point out that the reply brief of the defendant really does a couple of things. Number one, she keeps talking about reckless, but then she quotes from cases that are not reckless infliction cases. The Lemon case and the Rhodes case that she cited, she talks about how the Tennessee courts follow the restatement section 46. Under reckless infliction, the Doe court specifically rejected that theory and specifically said that we don't follow section 36. The DeSoto case that she cited was an employment discrimination case. It was an intentional infliction of emotional distress case, as were the prior 2 that she cited. The Tennessee courts don't get into infliction of emotional distress cases in employment situations, and the court discussed that. Curiously, in the DeSoto case, the judge dismissed the case, which shows that the gatekeeper function of the trial judge works. Our judge, acting as gatekeeper, found that we qualified. The Cosart versus Jarrett Builders case that she cited, another intentional infliction case. All of them that she cited were intentional infliction cases and not reckless infliction cases. That one, again, was an employment situation, but that was a motion for summary judgment, and the court found that the plaintiff had made contradictory statements and dismissed the case, again showing that the gatekeeper function of the trial judge works. And lastly, she cited Doe versus Belmont University, which was an academic program case where he was removed, plaintiff was removed from the academic program, and the courts again said that the Tennessee courts don't get into academic disputes. But again, that was an intentional infliction claim. If the court looks strictly at the reckless infliction of emotional distress claims, there's no question, at least in my mind, that we qualify. And the Eskin case, for instance, that Mr. Grisham talked about, says that you should even allow negligent infliction of emotional distress claims when justice and fairness requires it. That case also relaxed the sensory observation and said that negligence didn't have to be from a single event, but as in this case, could be that they allowed this man to continue driving over this long period of time, even though they knew that he was intentionally trying to injure the children. Your Honor, I think that if you look at the history of the law, the Ramsey case, for instance, says that you just need a close relationship. We have alleged much more than just a close relationship. We have alleged that they had an intimate relationship. We have alleged details of the intimate relationship. I knew that teachers, for instance, bought supplies for their classrooms. I never realized that teachers in these impoverished areas are buying food for these children, spending time with them on the weekends, buying them food, acting as surrogate parents, and spending time with them even away from school. And to answer one prior question with regard to voluntarily going to the hospital, these teachers had been complaining about this driver, and I think that they were responsible for the children since these injuries occurred on the school bus. I think they were going to the hospital to see what they could do as their teachers.
Counsel,
This is a wrong situation.
Counsel, you've used your time. Thank you. We'll hear from the appellant in rebuttal.
Thank you. I will start with your question, Judge Sweeney, with respect to the requirement that reasonable foreseeability is an element of the intentional infliction of emotional distress claim. This is set out in Doe at 154 Southwest 3rd, pages 22, 31, and 39. There are 4 elements of this claim. The conduct must be intentional or reckless. The conduct must be so outrageous that it is not tolerated by civilized society. The conduct must result in serious mental injury, and the plaintiff must fall within the reasonably foreseeable scope of the particular substantial and unjustifiable risk consciously disregarded by the tortfeasor. That is the limitation which the Supreme Court has put on these claims, so that we don't have this really overbroad expansion. Reasonable foreseeability is absolutely required. Now, Doe did leave open, or I should say at least did not address how the reasonable foreseeability would be assessed, which is why we submit that the appropriate analysis is the analysis applied and set out in Ramsey and Eskin with respect to the negligence claims, because recklessness and negligence, foreseeability is really the unifying factor. That again looks to the plaintiff's location and awareness at the time of the accident, awareness at the time of the accident, the injuries suffered by the third party, and critically here, the nature and closeness of the relationship between the emotional distress plaintiff and the specific third party who was injured. And those facts, there are many facts in the complaints, the operative complaints regarding Durham and Walker's alleged conduct. There are no facts alleged describing the specific relationships between these specific plaintiffs and the specific children who were injured or killed in the accident. Judge Davis, to your point regarding a significant expansion of intentional infliction claims, if Judge Bennett was right, you are absolutely correct. This would really make this a limitless tort. which would be a very unusual situation to have such a broad availability of an intentional infliction claim, but a narrower availability for a negligent infliction claim. There really is nothing in the Tennessee Supreme Court's jurisprudence on these claims, starting with Camper versus Minor and moving forward, that would support such a broad expansion. And in fact, I would submit further that such an expansion would really be unprecedented in the country. At page 27 of our opening briefs, we have a very lengthy footnote setting out cases from all other jurisdictions that have specifically focused on the family nature of relationships and rejected claims brought by friends, colleagues, co-workers, and folks of that nature. With respect to your question, also, Judge Davis, regarding does it matter if these plaintiffs voluntarily went to the scene of the accident or the hospital? That really pertains to only Mrs. Cothran's claim, because that goes to the negligent infliction of emotional distress. Yes, it does. And we discussed that at page 32 of our brief in Ms. Cothran's case, and that was not responded to in her appellee's brief. But there is case law, albeit not from Tennessee, but we cited case law of other jurisdictions which have held that, when you have time to kind of brace yourself or prepare yourself for what you're about to see, that's a factor in the analysis in terms of the emotional distress aspect. The final point I would like to bring up and raise is to note that Mrs. Cothran did not oppose dismissal of the intentional infliction of emotional distress claim, either in the trial court below or in her brief before this court. And so we submit that that's really an implied concession on her part that her claim should not have survived Rule 12 in our motion. If the panel has no further questions, I will rest on our briefs and respectfully request reversal in all 5 cases.
I hear no more questions. Thanks to counsel for both sides, from all of it. Your briefs and your oral arguments certainly made that believe the issues and your positions are clear to us. So thank you for that. Mr. Hibner, if you'll adjourn court till tomorrow morning.
This honorable court is now adjourned for the day.